Get ready. Start. The Jammu and Kashmir and Ladakh High Court ruled that Sub-Rule 3 of Rule 1 of Order 16 CPC confers a wider jurisdiction on the court to cater to a situation where the party has failed to name the witness in the list or the party is unable to produce him or her on his own under Rule 1A, and in such a situation, the party out of necessity may seek the assistance of the court under Sub-Rule 3 to procure the presence of the witness. Stop. The petitioner challenged the order on the ground that the same is perverse and illegal, as the same was passed without taking into consideration any cause, much less a good cause, shown by the respondent, who had filed 3 different applications for examination and summoning the witnesses. Stop para. Counsel for the petitioner further submitted that the grounds carved out in the application are only an afterthought to defeat and delay the trial, and the trial court had erroneously accepted the affidavits of 2 persons who were cited in as witnesses, even though the application for permitting them to examine witnesses was yet to be decided, and this in turn resulted in delay in the proceedings. Stop. Contesting the plea, the respondent submitted that during the pendency of the suit, the original defendant expired and his daughters, being the legal representatives, were brought on record. Stop. The legal representatives of the defendant, it is stated, despite availing all efforts, were unable to contact many witnesses, as some had died and some had left the place of residence and moved elsewhere, they have thus even deleted 10 witnesses as mentioned in the list, the counsel argued. Stop para. Counsel for the respondents further submitted that the respondents, had moved an application for allowing them to examine witnesses as given in the list in place of list of witnesses already submitted by the defendant, and hence the trial court, after hearing both the parties, allowed the application of the respondents under Order 16 Rule 1 Sub-Rule 3 and Order 16 Rule 1A. Stop. Adjudicating upon the matter, Justice Sindhu Sharma observed that CPC is amply clear on the subject that party desirous of obtaining any summons for the attendance of any person shall file in court an application stating therein the purpose for which the witness is proposed to be summoned. Stop. This disclosure enables the court to decide as to whether the examination of such witness to decide is necessary to decide the dispute or not. Stop para. The advance filing of list of witnesses is necessary because summoning the witnesses by the court is a time-consuming process, and to avoid the avoidable delay, an obligation is cast on the party to file a list of witnesses whose presence the party desires to procure with the assistance of the court. Stop. In view of the aforesaid legal position, the bench observed that the trial court had rightly allowed the application for examination of the witnesses, and the contention of the petitioner that this application was only to delay the trial is also without any merit, in view of the fact that the respondents have already deleted almost 18 witnesses and 2 have died during the pendency of the trial. Stop over.